Yes, any mention?
Yeah,
Yes.
this Lordship. Lordship, I'd like to mention hearing item number 7, Your Lordship. Lordship, here my senior is on leave, Your Lordship.
I can appreciate Hornbill Festival, but then when I come here, try not to take time.
Lordship.
All right.
Since your
So
apology.
today you are for the state.
No.
Acha, it's the other side. I mean,
Yes.
different from other courts. The appellant stands there.
Yes, state is appellant here, Lordship.
State is the appellant.
Yes.
So you are the appellant.
Yes, Lordship.
You don't have any problem.
No. This, since the convict is behind jail, we have no problem. We are, the convict.
You want an enhancement.
Yes,
What has happened to the appeal preferred by the accused?
they have not preferred appeal, Lordship.
They did not prefer an appeal.
No. But state is not satisfied with the conviction under three.
That's right, we have put that. You are not satisfied with conviction under 304 part 2
Yes,
or part 1,
yes, part 2, yes.
part 2.
Yes.
They don't say, the judgment doesn't say whether it is part 1 or part 2, doesn't matter. But then no appeal was preferred by the respondent here.
No,
No jail appeal like that.
I think jail appeal, but he must have, no, not even a jail appeal was preferred.
no, Lordship.
Are you sure?
Yes.
Well, can I have your name, please?
My name is K. Angami, Lordship.
Mr. K. Angami, learned advocate for the appellant state, is present. However, an adjournment has been sought on behalf of the respondent / accused on the ground of non-availability of the learned advocate who is to address this court. Let this matter come up for consideration under the appropriate heading on which date?
After vacation, Lordship.
Well, vacation is a long time to go, no? We always give dates, and we will be requesting my brother judges also to give dates. No 4 weeks, 3 weeks. Anyway, in January,
Lordship.
you're in jail, you should not take time. Right?
Lordship.
Sometimes in January when it reopens, give a date. All right. Anybody who will be here will do it.
Much obliged, Lordship.
All right.
Yes.
Any other matter mentioning?
For orders, item number 1.
Return of service of notice.
Wait, your lordship. The IA is for continuing.
Condonation of delay of more than 1,000 days.
Yes, lordship.
Who appears for the respondent?
Lordship, I'm for the state.
No, private respondent would be necessary.
To our office, notice was directed to be served, and we have received the acknowledgement from the concerned police station.
Yes.
So notice upon the private respondents affected, Lordship.
Notice has been effected,
Yes,
but then we'll give one more time.
Lordship.
Ah.
Lordship.
Of legal aid council.
Hmm?
You can open legal aid council. Legal aid council.
No.
For hard to, can you legal aid?
No, if he doesn't come on the next date, we will appoint some counsel on his back. Today, we will look. Take that. This is an application seeking condonation of delay of 1181 days in preferring the appeal. The counsel for the state is present. He submits that notice to respondent number 2 / private respondent has already been effected. However, there is no response. However, there is no appearance on behalf of respondent number 2. This court, in all fitness of things, considers it desirable to appoint one legal aid counsel to resist the application for condonation of delay. Do we have a list of legal aid counsel here? Do we have a list, Mr. Court Master? Do we have a list of legal aid?
Legal aid council, list.
The registry, the legal aid services authority, the state legal aid services authority shall nominate one of the panel advocates to appear in this matter on behalf of respondent number 2. Let this matter come up for consideration on so and so date. sometimes in January again.
Obliged, Lordship.
For orders, item number 2.
This is also similar matter.
Same.
Yes, similar order may be possible. We have,
This is delay of how many days?
485 days, Lordship.
485 days.
Yes, Lordship.
Notice has been served.
yes, it's affected like the item number 1.
Actually, here there's an application seeking condonation of delay of how many days?
485 days. Lordship.
Of 485 days. 490 days or 85 days?
85, Lordship.
485 days. First up, the counsel for the state is present who has informed this court that notice to respondents number 2 and 3 has already been effected.
2, only 2.
Notice to respond number 2 has
No order was passed as regard to
not
respondent
with respect to
Respondent number 3.
number
Lordship.
3, in the last occasion.
has notice been issued to respond number
No,
two?
Lordship.
Has already been effected, but there is no appearance on behalf of respondent number 2. Again, the State Legal Services Authority, same order. First up, let fresh notice be issued to respondent number 3 on steps being taken by the applicant, appellant applicant, within a period of requisites to be filed within a period of 2 weeks, both modes returnable, sometimes in mid-January.
Obliged, Lordship.
Check up your calendar and then give the date.
Yes, Lordship.
All right?
For orders, item number 3.
I'm appearing for the appellant, my lord.
Yes.
My lord, there is 490 days delay, my lord. The appellant is residing in somewhere in Durgapur, West Bengal, my lord.
Yes.
This
That's
was the
right.
predicament, my
But
lord.
then notice has.
Notice was earlier, yes, my lord, earlier it was issued, my lord. 3 weeks time was granted, my lord, to the respondent to file objection to the delay, my lord. This was
But
the
nobody.
order.
Union of India.
Union
My
of.
lord, I believe Mr. Naguli, just Learned Counsel Naguli is appearing for this Assam Rifle.
Nobody is appearing. Nobody is
Mhm.
appearing today. So we do one thing, we adjourn this matter for today. Let's see if
Oblige,
something
my lord.
comes up tomorrow.
Again tomorrow, my lord. Oblige, my lord.
Let's see if nobody comes up
Ob-
tomorrow, we'll give a longer date. But then
Oblige, my lord.
today we pass it over.
Oblige, my lord.
All right, pass it over. Let this matter come up. Nobody, the counsel for the appellant applicant has appeared online. However, there is no appearance on. Yes, you are in this matter.
Yes, item number 3.
Yes. What do you have to say?
My lord, at least the Western Honorable Court, my lord.
No. Do you wish to object? Sir?
Yes, but still I have not received any.
You have not received any instruction.
Yes.
How is it that you are appearing before us? How are you appearing before us?
Instruction to object.
No, you have no instructions to object.
Yes, my lord.
All right. There's an application seeking. This is for you are appear for respondent number 2. You appear for
My
whom?
lord, I believe, my lord, for all the respondents. Because in the
Just a minute. Just hold on for a minute. Are you appearing for all the respondents?
Yes, my lord.
You are a government for the central government.
Yes.
You are a counsel for the central government.
Yes, my lord.
What is your name?
That only, my lord.
Mr. So-and-so has appeared, Selico. There's an application seeking condonation of delay of how many days?
490, my lord. 490.
490 days in preferring this appeal. Mr. So-and-so has appeared on behalf of the respondents. So-and-so, learned central government council has appeared on behalf of the respondents and has submitted that there is no clear instruction to oppose the present application for condonation of delay. We have gone through the application and have found that good grounds have been made out for condoning the delay of 490 days in preferring the appeal.
Highly
For
obliged.
the reasons stated above, the delay of so-and-so days is condoned. The application stands allowed the registry to process the appeal and get it listed in the 3rd week of January.
But
Oblige, my lord.
For admission, item number 4.
Yes,
May I plead your lordship?
yes,
Lordship, I am appearing on behalf of the petitioner in the
Yes.
instant petition. Your lordship, first of all, before going into the facts of the case, I would like to apprise the honorable court that today is the last expiring date of the detention order.
wait for today. Wait for today. We would, it would be no great use going through the merits of your application because the period expires. And has the matter been placed before the advisory board?
Lordship, as per the whatever documents I have received from the detaining authority, there is no such report of the advisory board, but definitely in my
Yes.
detention order, they have stated that my detention order has been placed before the advisory board. But regarding the report of the advisory board, I have not received your lordship, and that is also
So
one of my.
therefore, I think you would be better advised, instead of us passing any order on your application, you take time today for the reason that if there is no confirmation by the advisory board, you shall be released otherwise.
Lordship, in that matter, I don't know whether any state respondent or central.
We have followed that. We have followed that. Therefore, we are asking you that you take a week's time. In the meantime, if the advisory board's opinion comes, all right. Otherwise, you shall be released because the period would expire.
Lordship, and today is the last date, Lordship, for detention order.
Are you following what the court is saying?
Lordship,
We are saying it for your advantage. So
Lordship.
what would be the purpose of dealing with this petition when you have no information with respect to the advisory board
Yes.
having opined in this matter? And the
Lordship.
date is over. That is for 3 months, the date would be over today.
Yes, Lordship.
All right. So otherwise also you'd be released. What we do is we adjourn this matter for 1 week.
Lordship.
Like here. Why do we adjourn? We have heard so and so on behalf of the petitioner online. Stop. He submits that today is the last day when the period of detention expires. Stop. He has no idea whether the detention order was placed before the advisory board for its confirmation. Stop. In any view of the matter, in this view of the matter, he seeks a week's adjournment. Stop. If there is no confirmation by the advisory board, the petitioner would otherwise be released. Stop. Let this released from jail. Would be released. Let this matter come up for consideration on give a date after a week.
Your Worship,
Lordship.
may be recorded. Our names may be recorded.
Your presence may be recorded.
Yes, sir.
All right. What is your instruction? We will record your presence only when you tell us what has happened.
So,
Mere presence, mere standing before the court would not do,
Yes.
no? You have to tell us.
we have not received any instruction till date. However, this since the matter has come up,
So and so,
Your Lordship, as far as the state is concerned, Your Lordship, I have already filed my affidavit, Your Lordship.
we don't want any other affidavit. We want that information, whether the matter has gone to the advisory board. Otherwise, this doesn't continue any further, no? Have you said anything about advisory board?
Yes, Your Lordship.
What have you said?
It has been, the advisory board has already given the
Opinion.
judgment opinion, Your Lordship.
Confirming it.
Yeah, yes.
But then the period ends, no?
The period ends today, Your Lordship, and as of now,
You have not
this time-
taken any steps to further extend it.
Your Lordship, it seems the steps are taken. But I am yet to get the official letter. Official-
So you'll have to release it on today. If there is no order today of any
Yes, Your
extension, you will have no option but to release the petitioner.
So far as this time now, no order has come out so far.
What do we say? That doesn't speak good of the system, no? What have I said?
If there is no proposal, whether advisory board, but it's,
No, ऐसा नहीं को काटो ना. He says that he has no idea. आपने अभी लिखा ना कहाँ तक लिखा है?
there's no right to continue. So, conduct a good place before the advisory board.
Learned counsel, so and so appears, so and so has appeared for the respondent state. First up, she submits that according to oral instruction, she submits that the advisory board has confirmed the detention of the petitioner, but there is no order on date extending the period of detention. Full stop. In that case, the detention period expires today. Full stop. In that view of the matter, the petitioner would be released from jail, will be released from detention. Full stop. Thus, there would be no necessity of adjudicating this petition.
Your Lordship, my submission will be, so far as of now, I have not received, Your Lordship. There is
But
no.
today, if you have not received, then that is today. Anyway,
So let that be the opinion of this court, Your Lordship, not my submission, Your Lordship. My humble request, Your Lordship.
but there is no information as on date whether any decision has been taken by the executive to extend the period of detention. Stop. Let this matter come up for consideration on the next date, so as to enable the learned counsel for the parties to update the court about the status of the petitioner. Sorry, yes.
For admission, item number 5.
Same thing. 4 days. Now, what is your instruction here? This also, the period expires after a week.
It's on 6th, Your Lordship. Yes,
6th.
on 6th.
So today is 4th, 4 days later.
Yes, my lord.
Confirmation by the advisory board? Confirmation by the advisory. Don't press it today. Don't press it today. After a week, if there is no order, you would automatically be released.
Confirmation order, I have annexed.
You have been detained. Let me explain it to you. You have been detained by an executive order.
Yes, ma'am.
The order has been confirmed by the chief secretary,
Yes, ma'am.
but this confirmation has to be approved by the advisory board.
Yes, ma'am.
Advisory board also has approved. Approved of what? Approved of the detention for 3 months. So there has to be a government order for further extending that.
Yes, madam.
So if there is no order,
Yes, madam.
you would automatically be released. So take time today, seek an adjournment after a week. If the matter comes up before the court, whichever court is sitting here, you shall say that the period has expired, there is nobody, I have not yet been released. So you'll be released. Anything else? Have you understood?
Yes, my lord. But my lord, in case extension order is passed, I have to file affidavit again. You can file again.
If extension order is filed again, then perhaps you can pursue this petition and say that the orders of your first detention was wrong. Try and understand, how many years have you put in, gentlemen? How many years? Young counsel, you need to be trained, no? So the advisory from the bench is that you seek an adjournment of 1 week. In the meantime, if nothing happens, you succeed otherwise. If something happens, you press this petition. Right?
Yes, madam.
You are still not satisfied.
If the matter can be fixed, a date may be given.
We shall give a date.
Will be on 9th of.
As prayed for, let this matter come up for consideration on so and so. Perhaps you will not be required to argue.
Hello, Blackman.
For admission, item number 6.
May I plead your lordship?
Yes.
Lordship, I am appealing on behalf of the petitioner in the instant.
The
petition.
period expires on 6th of December.
Lordship,
So what is your instruction in the matter?
Your Lordship, I've already filed an affidavit, so, but as per the distinct confirmation, Your Lordship, I have no instruction.
Same.
It's the same one.
We are adjourning it for a week.
lordship.
As prayed for, we let this matter come up for consideration on so and so. On the next date, whichever judge is sitting here, you tell him that there is no extension and therefore you should be released. Or maybe if you're already released, withdraw this application on the next date.
Lordship.
All right. List is over. We will come back tomorrow.
Okay, I'm